Hi, this is the Business Guy. Today we're going to talk about a living trust, what it is and how it can help you. And you'll especially want to watch till the end because we're going to talk about the most important thing, and that's how to put assets into the trust. So what is a living trust? A living trust is a document that consists of three main parties. The settlor, who has the trust established, this could be you, for example. The trustee, who manages the trust, and this can initially be you as well. And the beneficiaries who benefit from the trust, and this can be you, and then upon your passing can be your heirs. Now, if it involves a married couple, a living trust will typically state that the trust assets go to the surviving spouse and then to their children when both pass. Now, I've been in the asset protection business since 1991, and our company was formed in 1906. I teach seminars to attorneys, CPAs, and business people, and I believe we have over 65,000 clients in our database, and we have established literally thousands of trusts and companies over the year. And by the way, if you're watching this on YouTube, please click the like button below and enter your comments. And you can also click the subscribe button so that when more videos come out like this, you'll get notified. Now, for larger estates, there is the AB trust, where Trust A transfers half of the assets to the surviving spouse. The other half goes into the B trust, and the surviving spouse gets the investment income from the B trust. When both die, Trust A and Trust B transfers to heirs, doubling the amount that can be transferred estate tax-free. Now, a living trust provides three main benefits. Number one, to avoid probate. And probate is the legal process of distributing property from the one who has died to others. And during the process, the courts distribute property, resolve claims, and most always there are attorney's fees as well as court costs associated with taking a will through probate. In addition, those who are to receive the proceeds of a will are unable to receive those proceeds immediately and not until the probate court has approved the distribution. This process can tie up their proceeds from a few months to several years. And if your heirs bring your will to the bank and attempt to withdraw money after the death, the bank will not allow them to touch the funds. The probate court must grant the bank permission. With a properly drafted living trust, on the other hand, it is a different story. Those who you name in your trust can generally go to the bank, bring a copy of your trust along with their identification and your death certificate, and they can withdraw funds immediately in accordance to the trust agreement. Number two, lawsuit prevention and protection. Now, many wills are legally contested, and having a living trust can drastically reduce the risk of an estate-related lawsuit. Plus, whereas a living trust is not an asset protection device, it may give a lawsuit protection benefit to a married couple when assets are held between two trusts. Assets in a properly drafted trust for the wife can be insulated from acts of the husband, for example. And a lot of this depends on if you live in a community property state or not. We can, however, convert a living trust into an asset protection trust, which, especially if established offshore, is one of the strongest asset protection devices available. Number three is sheltering your estate. You can shelter all or a large portion of your estate when you have conformed to sections 2056 and 2041 of the IRS tax code. Having property or money in your revocable living trust does not require you to change your federal tax filing. It is analogous to you wearing a different colored hat. You can simply file your taxes the same way you did before you had the trust. Now, how to put property into a living trust. This is the important part. First of all, title. You can change the title to the property. For example, you can go to the bank and bring your trust document. Then you can ask the banker to transfer your accounts into the trust. For real property, you simply fill out a quitclaim deed, for example, and transfer your real estate from your name into the trust. Schedule A. Number two, you can list the property on a Schedule A. A Schedule A is a piece of paper that is usually attached to the back of the trust. It simply describes the property that you would like to have included in your trust. For example, the brown china cabinet, the red antique clock from Germany, my Hewlett-Packard printer model number JJ54436. And each time you change your Schedule A, it is best to have it notarized. Many people update their Schedule A once a year when they buy expensive items. You can also have a pour-over will that says anything that you forgot to put into the trust automatically will be processed through your living trust. And it is often best to do both of the above, change the title and list it on your Schedule A whenever possible. For example, ask your banker to change the title to your bank account into the name of your trust. Additionally, you can list Bank of America account number 005331242 on your Schedule A. This is an additional help and a guide to your heirs for your various bank accounts and investment accounts so they know where they are. Revocable. Now, you can modify your revocable living trust at any time. You can be the trustee. The trustee is the one who manages the trust and holds title to the assets, legal title to the property in the trust for the benefit of another person, which can also be you. The trustee is also required to follow the directions outlined in the trust document. That is, you can control your trust. You can change the beneficiary as many times as you like to. Beneficiaries are those who receive the proceeds of your trust, usually upon death. If you like, you can have another person or company act as the trustee, and per the trust document, they are usually to perform the duties under your direction. You can also typically change who the trustee is at any time. The trustee can change, and you can put your money or property into your trust and take it out whenever you like. A land trust. Many people who have real estate holdings title each property into the name of a different land trust. Then they have a company who provides trustee services stand in as trustee for privacy of ownership of the real estate. A trust is a name that is not associated with the one who had the trust set up. For example, 123 Main Street Land Trust. So if anybody does a title search in the public records, the one whose name is in the public records and holds the title does not have to be you. So you have privacy of ownership. Then all of these land trusts funnel into one or more limited liability companies for lawsuit protection and asset protection, and the living trust in turn owns the LLC. Now, let's talk about asset protection and estate planning. Owning property in a revocable living trust does not provide you more actual lawsuit protection than owning the same property in your own name. That is why people use living trusts in many cases in combination with asset protection devices. Many people hold title to their limited partnership or LLC in their trust. For example, the parents hold their 2% general partnership interest in their trust. Then the children share the remaining 98% of the limited partnership interest or LLC interest. Again, a living trust does not provide asset protection from personal lawsuits. A properly structured limited partnership or LLC can. That way, when you pass away, the managing party in the company, your general partnership or LLC management interest, can go to those whom you name. And it does so without having to go through expensive and time-consuming probate procedures. Now, we highly recommend that you review all trust documents in detail with knowledgeable estate planning specialists and do so before implementing them in your estate planning or financial plan. In fact, we have attorneys on staff who can help, and laws vary and change from time to time, and your specific needs may vary. So please give us a call at 1-888-444-4812, or you can complete a free consultation form at companiesinc.com. This is The Business Guy, and thank you.